Hello. In this clip from our Justia webinar, Confronting Racial Bias in Jury Selection, Angie Setzer discusses the importance of having representative juries to ensure equality and fairness in the legal process. If you'd like to see more Justia videos on law practice and legal marketing, be sure to subscribe to our channel.
Okay, so I'm just going to jump into the history here after that short introductory video, which kind of is an overview of what we'll be talking about today. As most of you know, the right to a trial by jury is sort of a core tenet of our democracy, right? The idea that you would be tried by neighbors, friends, community members, largely because it prevents the accused from government overreach, from abuse. And unlike prosecutors or judges who were largely appointed or elected, jurors represent ordinary citizens who, represent our values and norms. As our courts have long recognized, and Justice Kavanaugh did in the most recent Flowers v. Mississippi opinion, other than voting, serving on a jury is the most substantial opportunity that most citizens have to participate in the democratic process. But despite how critical and how important it is for juries to protect community members against government overreach, Black people have been excluded from jury service really since America's founding. To justify the mass enslavement of Black people in a country founded on freedom and liberty, an elaborate mythology was created and emerged based on the idea that Black people were inferior and not fully human. And this in turn was incorporated into the legal system, which became a critical mechanism for enforcing white supremacy. We see this in our, sort of documents, right? The Constitution denied Black people the right to vote and to serve on juries by characterizing them as property, right? We classify enslaved people as property. Most states denied free Black people the right to serve on juries and a jury trial. And these provisions left African Americans not only unprotected from abusive prosecutions, but also vulnerable to violence and exploitation because perpetrators of violence would not be held accountable. After the Civil War, during this sort of 12-year period that we know as, that's called Reconstruction, there was significant progress towards racial equality. And in fact, ensuring that African Americans participated in the legal process was a priority. And so we see this, right? We see this in the 14th Amendment, which guaranteed the full rights of citizenship to citizens regardless of race, ratified in 1868. The 15th Amendment, which guaranteed Black men the right to vote, ratified in 1870. And then there was a series of federal laws which authorized individuals to go to federal court for civil rights violations and authorized and empowered the federal government to prosecute civil rights violations as federal crimes. Those are the Enforcement Acts and the Ku Klux Klan Act in the 1870 and 1871. And then I want to mention the Civil Rights Act of 1875, which I'll come back to later in the presentation. This act specifically outlawed race-based discrimination in jury selection. At the same time, during this 12-year period of Reconstruction, white resistance to racial equality grew increasingly violent. More than 2,000 African Americans were victims of racial terror lynchings from 1865 to 1877. And the white perpetrators of these racial terror acts were members of the community. They were law enforcement officials, they were sheriffs, they were community leaders, they were elected officials. And they committed these acts with no fear of prosecution or conviction in an all-white legal system. Amidst this racial terror violence, the Supreme Court sort of began its own assault on the progress that was being made towards racial equality. Prior to 1865, the United States Supreme Court struck down 2 congressional acts as unconstitutional. But between 1865 and 1872, the court struck down 13 congressional acts as unconstitutional. And I want to just highlight a couple of these subsequent Supreme Court opinions. I think these are opinions that we all were familiar with and I remember reading about in law school. The first was the slaughterhouse cases, in which the Supreme Court held that the 14th Amendment's Privileges and Immunities Clause, which was actually specifically written to protect the rights of formerly enslaved people, did not apply to rights derived from a person's state citizenship. And so those rights are only enforceable in state court and not federal court. Of course, state court was a forum dominated by the white ruling class and hostile to claims by African Americans. And then, of course, we had United States v. Cruikshank, which was a case where the United States attorney in Louisiana had actually prosecuted and brought federal criminal charges under the Enforcement Acts against the white perpetrators of the Colfax Massacre. In that case, the United States Supreme Court held that the 14th Amendment provides protection only against actions of the state and not against individual acts of violence, which essentially eviscerated the Enforcement Acts entirely. So towards the end of Reconstruction, we have sort of an end to political progress. And at the same time, it meant that essentially the right to vote and the right to serve on a jury was never fully realized. Although the court upheld the provision on the Civil Rights Act of 1875, which was a prohibition on racially discriminatory jury selection, state and local officials largely ignored this federal law or just found ways around them. And so in late 1800s, we see examples of this, of the ways in which states are getting around any sort of, federal prohibitions that are left. And one example I want to highlight is Louisiana. So in 1898, the Louisiana legislature amended its constitution with the specific purpose of establishing white supremacy. And so in order to dilute the participation of Black jurors, the legislature passed a law which would allow a felony conviction even without a unanimous verdict, meaning that they only needed 9 out of 12 jurors to convict. So even if you had 1, 2, or 3 Black jurors on the jury who voted to acquit, that was not sufficient, and we could still convict based on 9 out of 12. This practice, again, specifically designed to uphold white supremacy, was not overturned until the 2020 case of Ramos v. Louisiana. Other states were doing the same kinds of things, and so throughout the early 1900s, the United States Supreme Court largely turned a blind eye to what was happening, to the rampant and illegal exclusion of people of color, and just sort of deferred to state findings that no discrimination was happening. We see this in cases that came out of Texas, in death penalty cases where, there would be a county that was over 25% African American, and we'd have a Black man sentenced to death by an all-white jury. And the Texas court was simply saying, it's fine, there's no discrimination here based on the state court findings. At the same time that the court is sort of ignoring what's happening, again, the racial terror lynchings and this white resistance to equality was continuing to be more and more violent. EJI has documented that between 1877, so the end of Reconstruction, in 1950, more than 4,400 African Americans were killed in racial terror lynchings. So the Supreme Court's largely turning a blind eye. In 1935, they did something, they sort of called out local officials. This was in Norris v. Alabama, a case where 9 Black teenagers had been accused and convicted of raping a white woman, despite significant evidence of their innocence. In that case, there was an all-white jury. The testimony established that not a single African American had served on a jury in living memory. And in that case, the United States Supreme Court finally reversed about 6 other cases over the next 12 years under similar circumstances. But the Supreme Court's commitment to racial justice, or eliminating and eradicating racial bias in jury selection, was fleeting. And, states continued to devise ways around any sort of prohibitions. States would come up with putting names on different colored sheets of paper. You'd have Black jurors on one sheet and white jurors on another. The states would rely on segregated tax rolls to form their jury pools. In one case, the United States Supreme Court upheld a Texas county's practice of allowing just 1, but no more African Americans on a grand jury. And the Supreme Court said that was fine. So it really wasn't until the 60s and 70s in cases like Swain and Taylor v. Louisiana that the Supreme Court really began to confront and address the exclusion of Black people and people of color from jury service in earnest. Before I sort of jump into all the different ways in which sort of what's happening in terms of representative juries now, I want to just pause for a minute and talk a little bit about presumption of guilt. So the presumption of guilt is basically how our country's failure to adequately confront this history of racial injustice that I just touched upon has evolved into a widespread presumption that people of color are suspicious, dangerous, and criminal. So, what we've just learned is that the legacy of slavery was the myth of racial hierarchy, or the false racial narrative that Black people are inferior, which was created to justify the mass enslavement and really survived the formal abolition of slavery. This myth was reinforced through racial terror lynchings, where white people defended the brutal torture and spectacle murder of Black people as necessary to protect their property and families and way of life. And this myth continues today as a presumption of guilt, which is assigned to people of color, which really targets them for unfair treatment in the criminal justice system. Black men are 6 times more likely to be incarcerated than white men. Latino men are 3 times more likely than white men. Bureau of Justice Statistics in 2003 predicted that 1 in 3 Black young boys and 1 in 6 Black Latino boys would go to jail or prison. And it also has created this sort of implicit bias, which I'm going to talk a little bit more about in just a minute. But numerous studies have demonstrated that as a result of this history and our failure to adequately confront this history, people have strong unconscious associations between Blackness and criminality. This bias has contributed to the mass, incarceration that we see today. U.S. prison populations have skyrocketed from, a few 100,000 people in the early 70s to over 2.2 million people today. So I just want to sort of have that in mind as we move forward and talk about the importance of representative juries.
Thanks for watching. We hope you enjoyed this video, and if you did enjoy, please hit the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next clip.